and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and song of the court.
Good afternoon. Our next case is NC Department of Environmental Quality versus the NC Farm Bureau Federation, Inc. We will hear from the appellant.
Good morning, Your Honors. May it please the Court. My name is Taylor Crabtree. I'm with the Department of Justice, and I'll be representing the Department of Environmental Quality in this case. I'd like to reserve 5 minutes of my time for rebuttal. This case concerns general permits for animal waste management systems at swine, cattle, and wet waste poultry operations. The Court of Appeals held that the conditions in these permits are rules that were required to be adopted through rulemaking. This was error. For at least 20 years, the General Assembly has known that these permits were being issued as permits, not adopted as rules. And despite interacting with the program on multiple occasions and directly intervening to refine the division's process for issuing these permits, it is never required that these permits be adopted as rules. The more general text of the APA does not do so either. To be a rule, a statement, regulation, or standard must have general applicability. These permit conditions do not. For these reasons, we ask that this court reverse the decision of the Court of Appeals and remand for that court to address the Farm Bureau's alternative claim. Now, a clear example of the General Assembly's intent not to require that these permit conditions go through rulemaking comes from the 2003 session law that we cite at pages 85 and 86 of our appendix.
Before you get there, can I ask you a question?
Sure, you got it.
Suppose the General Assembly enacted a statute and they said, we want to delegate to this agency some regulatory power, but we're sick of the APA. So there'll be no procedural safeguards. This doesn't go through the APA. It's not subject to rules review and the Rules Review Commission. Go out and promulgate your regulations. Does the General Assembly have the power to do that, in your view?
Your Honor, I think there would be a lot of questions there. No procedural safeguards whatsoever, and the agency can just dictate by executive fiat with no notice and comment whatsoever. That'd be a very different case than this one. There would be some due process claims which haven't been made in this case, and it's uncontested that this permitting process is substantially different than that.
What I'm getting at is, and this is because what I'm seeing in this case is that we have, I think, a constitutional avoidance issue that your friends referenced because of separation of powers, because our case law about regulatory rulemaking by the executive branch is so limited in North Carolina. So unlike in federal law, where the only limit that comes from non-delegation is because we infer in the structure of the United States Constitution that there's these limits. But we have this provision that says the powers of the three branches must be separate and distinct. That's expressed in the Constitution. And so what we've said, this court, is we will allow, because of just the realities of the administrative state, to permit the legislative branch to delegate some of that power, or lawmaking power, to the executive branch because we know it needs to be done. There are agencies like DEQ that it would just be an impossible task for the folks on Drone Street to have to hire thousands of employees that are experts in all these different areas to draft these rules. So they say, we'll give it to the agency. But we said, when we did that it will be subject to some sort of limitations. And those were that there have to be procedural safeguards, that you can't do it unless you have something like the APA and you have rules review. And that's in the Adams v. Diener case. And what I'm trying to figure out here is if we follow that standard here, even if we agree with you that, the legislature pretty clearly said this doesn't need to go through the APA, you can just use the permits. If the permits themselves, when we look at them, like the Court of Appeals said, are providing a general rule that's going to apply to everyone unless the agency gives someone an exception. That sounds like rulemaking, which would be lawmaking, but by an executive branch agency. So what am I missing? Why isn't that a problem here?
So I think that it's the last point that you're missing. These permits are not rules. They don't set a general standard that applies to everybody, because as a matter of law, these permits are, any permittee has the option to request an individual permit instead. And so they don't apply categorically in that way. And so the whole
So I guess my question would be, though, if that's the case, where in the statute do we find the intelligible principle that would allow the permit applicant to say, here is the statutory law that I would need to comply with in order to know I'm going to get the permit? Because it does seem like it's the reverse. You really don't, the permit itself will tell you what the rules are. And in order for a system like that to exist, those rules and the permits would have to go through some procedural safeguards because they're laws.
No, Your Honor, I don't think so. So first, there are rules that apply to these permits that have been adopted since the beginning. The relevant statutes direct the Environmental Management Commission to develop a system of individual and general permits. The Environmental Management Commission has adopted rules that specify what needs to go in these permits, the kind of conditions that can be included in them. It specifies the procedures that the department has to go through to issue the permits, notice and comment procedures. And then the General Assembly, as they did in 2003, has adopted additional procedural protections for these permits, the additional steps the agency has to go through before issuing these permits. And then even after all that, the individual applicant still has the absolute right to say, you know, I see those general permits, but I don't think they apply to me. I don't think they should apply to me, and I want to go seek an individual permit instead. And then the agency has to look at that permittee's operation and say, what conditions are appropriate for that permittee's operations under this whole same regime of rules? And then, even then, still, if that permittee thinks, hey, we don't think that a permit condition should apply to us, we think that it was contrary to law or arbitrary and capricious for the agency to apply that condition to us, we can go through the Office of Administrative Hearings and challenge that permit condition. So it's just not accurate to say that this rulemaking, this regime sets up a system where the permittees have no procedural safeguards. It's procedural safeguard after procedural safeguard. It's the General Assembly directing the Environmental Management Commission to set up a system of individual and general permits. The Environmental Management Commission setting up that system, delegating the authority to the agency to develop and issue these general permits. And then the permittee still having the option to say, yes, I'd like to proceed under this general permit, or no, I'd like to proceed under this individual permit.
Your argument seems to be that the conditions in the general permit can't be rules of general applicability because it's possible to obtain exceptions to an individual permit. Is that fair?
No, Your Honor, I don't think so. So obtaining an exception implies that it applies to you for ab initio. So in a like the zoning regime that our friends point to, in your property in a locality, it's subject to those zoning laws unless and until you secure an exception. That's not the case with these permits. With these permits, you at the beginning of the process have a choice. You can say, I'd like to apply for this general permit, or I'd like to apply for an individual permit.
But when you apply for, tell me if I'm wrong about this, when you apply for an individual permit, aren't you sort of negotiating which conditions in the general permit aren't going to apply to you in the individual permit?
No, I don't think that's quite how it works. It's, here's my operation, here's the details of my operation, just like you would apply for the general permit, and the agency would come back with the conditions that it thinks is appropriate. Now, it's true that the division has crafted a general permit based on what it thinks are the kinds of conditions that are necessary for the kinds of operations that we're dealing with here. So it might make sense to reference that in the back and forth with the agency, but it's not the case where you come in and say, we think, where the presumption is you get all the conditions and you have to negotiate away each one. It's you're applying for an individual permit. So I don't think it's quite the same as getting an exception from the general permit. It's if you think the general permit is appropriate, then it surely makes sense to apply for it. But if you think an individual permit is more appropriate, that's your right as well.
It's your right to apply,
It's your right to apply, and
but
if
you don't have a right to an individual permit.
no, I mean the record is perfectly clear. If you don't have a right to a permit at all. So, for example, if you there are certain things that the agency has the authority to deny a permit altogether. So, if you were going to be denied a permit altogether, you certainly wouldn't have a right to get an individual one. But there's testimony in the record from the permitting program manager that expressly states, and this is, let's see, I believe it's on page 613 of the documentary exhibit. I'm just going to quote this exactly. If any applicant who could have received coverage under one of the animal waste permits, that's the general permits that we're talking about here, instead applied for an individual permit, the division would process the application and issue an individual permit. So we would issue the individual permit. If you're qualified for the general, you can get an individual permit. Not just apply for one, get one. The rule itself that I think you're referencing, 15A NCAC 2TO111G, which has never been challenged in this case, expressly also gives, as a matter of law, the right to apply for an individual permit if you're subject to it, if you could also apply for a general permit. So we think both the law and the facts are clear in this case that you have a right to an individual permit. Full stop.
So,
Go ahead. Yes, sir.
I'm just picking out a random provision, but so one of the provisions of the general permit is you have to operate the facility so it will contain waste from a 25-year, 24-hour rainfall event.
Yes.
So I went down and ticked off each one of these. Did I hear you earlier say somewhere in a regulation, because I didn't see it, is each one of these criteria to tell
so that actually
you'll be entitled to a permit if you comply with, and then you can tick through all of these requirements in the general permit, and they're there in a regulation somewhere.
So I'll first speak to that specific one, which comes directly from 215.10C. That requirement is in statute. So any permit that you were able to obtain, individual or general, would have some version of that condition because that requirement comes from the statutes. There's other conditions that come directly from rules. There are some conditions that come from general authority to protect water quality, a more general authority, for example. And for those, they don't appear word for word in rule or statute. It's an exercise of agency discretion to include those additional conditions that are necessary to protect water quality. Otherwise, there would...
And that's what concerns me, because the agency, I don't think, has that discretion unless the legislature gives it. The only thing that the agency is allowed to do is to administer the laws, the environmental quality laws, and that includes regulations that the agency itself has promulgated. So your friends seem to have a good argument that when you look through the list, there just seem to be some requirements in here that are mixed in with other things that either the General Assembly said you've got to do this, or the agency has said you've got to do this, that the agency is saying you got to do this for the first time in the permits. And they're saying, well, this is rulemaking. And that it seems to me somewhat persuasive that otherwise the ability for the agency to, as you said, just in its discretion, decide what other criteria it wants to stick on a permit is allowing it to start regulating without any oversight from the General Assembly.
Well, without due respect, Your Honor, I don't think it's without any oversight. First, this is the same way it works for individual permits, which I don't think anybody contends are subject to rulemaking. There's agency authority to interpret the statutes and rules, and then to apply specific conditions applicable to the particular discharge or whatever the permitting regime may be, that would sort of apply those, interpret and apply those general requirements to the specific case and protect against the overall harms that particular permitting regime is designed to do.
But I guess what I'm saying is if you ask for the individual permit and The agency said, no, we're not going to give you the special permit based on this reason, which is not one of the reasons that's in the statute or in a regulation. You would have a claim against the agency. So there's no basis to deny it here. But so what's odd is you have this general permit you're laying out ahead of time saying you're going to have to comply with all these things. It's like you're informing the permit applicants, in addition to anything you see in the rules and regulations, you're also going to have to do these things. That really seems like rulemaking to lay it out like that. That's what I'm getting at. And because what's your remedy other than to challenge it and say, hold on a minute, I'm looking at the general permit, which I can see ahead of time. I'm seeing this thing in here that I don't think is authorized, which really seems to be what your friends are doing.
No, I mean, I think your remedy is to challenge that general permit. If for example, the challenge had been that we don't have the authority to include condition X because either it's contrary to these statutes or contrary to these rules, or it's unsupported, it's arbitrary and capricious, that's certainly a challenge that you can make. And we've never denied that, but that's not what was challenged here. In the record, you can find the division's director's testimony about why these conditions were included. There's rule and statute sites throughout the permit for these conditions, but the police never challenged the basis for the conditions. They just challenged them as unadopted rules, and so. It's not the case that you don't have a mechanism for challenging it. You have multiple mechanisms. You can ask for an individual permit like we've been talking about, or you can go directly challenge the general permit and say, we don't think these conditions are lawful. We don't think the agency has the authority to include them. And then we would have a fight in OEH about, do we have the authority? Is it consistent with the rules and statutes? That's not what happened here. We just went straight to, these are unadopted rules. The same sort of issue would come up in an individual permit, right? And we have individual permits all the time where the agency applies and interprets statutes and regulations and applies to that particular person. They don't know the conditions up front, right? But if they get the conditions and they don't believe that they should be applied to them, they do the same process. They go to OAH and they can challenge them saying, hey, this condition, this is not consistent with the rules governing the permitting program. You can't include that. You can't make me do that. We have those cases all the time. Or these conditions, this condition, yeah, you may have general authority to do that, but it makes no sense here because it doesn't serve the purpose. It doesn't serve any rational purpose, so it's arbitrary and capricious. We have those kinds of cases all the time in the individual context. That's no different than what we could do here. This is not the department just governing by executive fiat and doing whatever it wants. It's still constrained by the statutes and rules. If you look at...
Yeah, but I guess what I'm struggling with, and maybe I'm just doing a bad job conveying this, but the general permits, because it's published ahead of time and you've laid out the criteria, you as the applicant can see these are the requirements to get this permit, because I know now it's actually requirements that are posed by the permit, not some of them are not in any statute or regulation. But to me, if you're a permit applicant, you're looking at that, then you're going to say, okay, these are things that the agency has said are rules I have to comply with in order to get the general permit. Otherwise, I'll have to go and ask for a special permit. And when you just say it out loud like that, it really seems like what you're saying is, okay, well, it's just rulemaking. So I don't understand why the agency doesn't just say, well, let's just put it through the APA process then and let rules review take a look at it, and you wouldn't, would this lawsuit be over?
Well, so two things, Your Honor. First, I don't think that's any different than an individual permit where the permit applicant, the agency says after the fact, they say, here's your permit, right? You asked for a permit to do this, here's your individual permit. And these are the conditions under which you can do it. That's essentially the same thing. You're just getting an advance notice here. In either context, you can challenge that. And you can say, we don't think those should apply. We don't think they should apply to me here. And here you have this additional right to go seek an individual permit instead. Second, the general permitting process is not, it's designed to be flexible. There is a provision in these statutes designed to direct the Environmental Management Commission to include regulatory flexibility in this program to allow permittees to to try new things, to do new things, and to update these permits periodically. That's just not consistent with requiring rulemaking every 5 years. So with all due respect, Your Honor, I don't think that's the same thing. It's not just a simple, easy fix. And then we have 20 years of the General Assembly very clearly knowing that these permits are not being issued as rules and allowing them to continue to do so. So just quickly to the 2003 session law.
I'm sorry, before you
Yes, Your
get
Honor.
there, I'm still struggling with this conceptually. Suppose that there were no provision allowing for individual permits, that everyone who was going to operate a waste management system had to obtain the general permit. What would how would that change your argument?
I think that's a very different case, Your Honor. If this case was like an occupational licensing regime where the only option, if you wanted to have one of these animal waste management systems, is to proceed under one of these general permits.
But your rationale, or at least what I think I heard you say earlier, was, well, it can't be a rule because you don't have to obey the conditions unless you obtain a permit.
Right, Your Honor. No, you don't have to obey the conditions unless you obtain this permit.
Right.
Not just any permit, this particular permit,
Right.
and you have options to procure other ones.
And so then wouldn't you have to say that even if individual permits weren't available, well, it still doesn't amount to a rule because you're not subject to the conditions in the permit unless you obtain the permit?
No, Your Honor, I think that's a very materially different situation because I don't think the state can put you to this false choice where, we're only giving you one option, for example, right? If we were to say to permittees, sure, you're not subject to these permit conditions unless you apply for this permit, but oh, by the way, that's the only option available. I think that's putting somebody to a false choice where to pursue that particular activity, they have to accept these conditions, and that's not the case here. I think that would be a very different case, Your Honor.
But would it be rulemaking?
I think there's a very good argument that rulemaking would be required under those circumstances, and it's materially different than the case here.
Counsel, I think I heard you indicate earlier that the department has crafted a list of conditions to obtain a permit, and then you just recently said that it's perhaps impractical to update and notify of changes as they occur. How does that comply with notice requirements just under basic due process concepts?
Oh, Your Honor, I may have misspoke. That is not what I intended to say. There is extensive public notice and comment about these permits. These permits went through a full round of stakeholder comments where we invite stakeholders and take comments on them on the conditions that we're considering. And then there's a full round of public notice and comment process under the Environmental Management Commission's rules, which do go to the Rules Review Commission for issuing these permits. So this is not, it's not at all impractical.
Well, I'm sorry, so help me understand what you meant by as conditions change every 5 years, we just can't update our rules.
So I think requiring a full permanent rulemaking process every 5 years for these permits is a different thing than providing just the notice and comment about what's going to change. The full permanent rulemaking process is an extensive and time-consuming process.
Right, but you can make temporary rules.
You have to come within specific exceptions for temporary rules. They're not available just to update permits as they come along. So those are very defined procedures, as I'm sure your honors are well aware. Defined circumstances under which the agencies have the authority to adopt temporary or permanent rules that likely wouldn't be available where these permits were coming before the agency every 5 years.
I want to ask a question about the potential scope of adopting the Court of Appeals view here. And as I understand it, DEQ administers 21 different general industrial permits. And if we were to say that the conditions for the permitting process here have to go through rulemaking, does that mean that for every kind of industrial permit that has conditions, those would also have to go through rulemaking? And would this extend beyond DEQ to all of the state government operations?
So it depends, Your Honor. It depends on how broadly the court wrote the opinion. So, for example, there's a provision in the statutes for these permits that says that's the General Assembly's intent that most of the operations be permitted under general permits, and the Court of Appeals relied on that provision. And so, if this court were to write an opinion that relied on that provision to say that these general permits have to go through rulemaking, but we're not commenting on others, that might be a more narrow opinion. But if the Court of Appeals, but if this court simply said, you know, if you've got a general permit that applies broadly to some undefined most of a class, they have to go through rulemaking. That would apply to, as you mentioned, over 20 general permits that are maintained by the Department of Environmental Quality, and a whole host of potentially other general permits by other agencies. And it would place the activities that are authorized currently under those general permits in some doubt. So it would really work a great deal of uncertainty into the system. And we think, for that reason, we think this is a change that, if there's going to be a change made, it should be a change made by the General Assembly, who can anticipate that transition period, that huge amount of regulatory uncertainty that would be created that by simply throwing out a whole host of general permits all at once. It would involve legislative crafting to make that transition, and that's why we think the argument that Farm Bureau is presenting is an argument for the General Assembly and not for the courts.
But if it's grounded in the reality that of the non-delegation doctrine, that there just are limits when the General Assembly is giving regulatory power to agencies, because that's really legislative branch power, then this court isn't concerned with what the folks on Trent Street would think about it, because just like anyone in the executive branch, they don't get to say what the law is, we say that. So I don't find that particularly persuasive. And as to all those other categories of general permits, if the criteria in the general permit were authorized either by statute or by regulation, then the argument your friends are making here wouldn't apply, right? The only reason that it works in this circumstance is there are things in these permits where you can't look back and see some regulation or statute that's providing the intelligible principle of how that's in the permit. No,
Your Honor, I would strongly disagree with you, and I don't want to eat into too much of my rebuttal time, but that's a very, very important point. They've never raised a non-delegation doctrine. Throughout this case, that's never been an argument that the appellees have made. They've never raised a due process argument. It's never been an argument that the appellees have made. But critically, there's not been that argument, because each of the conditions in these permits has a statutory and regulatory site. Each of them have a tie, at least from the agency's perspective, to a particular statute or rule. It's not word for word, but it is an application of a statute or a rule for each permit condition. And so if we want to argue about that, if the Farm Bureau had wanted to challenge that basis, wanted to challenge the fact that we weren't tying it to a particular statute or rule, that's certainly an argument they could have made. They didn't. They never have in this case. So their argument is that because the precise conditions in this permit don't also appear in rule or statute, that's the problem. Not that we can't tie it back to a rule or statute, not that there's not an intelligible principle in rule or statute, but that the precise conditions here don't tie back to a rule or statute. And with that, Your Honors, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Mr. Chief Justice, Associate Justices, may it please the court, I'm Jake Parker, the North Carolina Farm Bureau Federation. With me at council table is Troy Shelton of the Dowling Law Firm on behalf of Farm Bureau. The first two paragraphs of the Administrative Procedure Act set out two fundamental principles that frame this case. First, General Statute 150B1A states that the Act, quote, establishes a uniform system of administrative rulemaking and adjudicatory procedures for agencies. The procedures ensure that the functions of rulemaking, investigation, advocacy, and adjudication are not all performed by the same person in the administrative process. Second, paragraph B confers, that is, grants procedural rights to the people of North Carolina. This case presents this court with an opportunity to make clear that the division cannot operate outside of the APA's uniform system of rulemaking unless an exception applies. Farm Bureau contends the division violated the APA by including 3 conditions in the general permits, even though they had not been adopted as rules. The Court of Appeals agreed, and this court should affirm. Before responding to a few of my friends' comments, it's important to emphasize the important procedural safeguards that are featured in the rulemaking process. At its core, as this court recognized in Empire Power, the rulemaking power balances competing interests between the agency's desire for efficient and speedy decision-making against the public's interest in having notice of the agency's activities and the opportunity to participate in that activity, that decision-making process. This balance is reflected in several APA provisions, such as 150B 19.1, which sets out the substantive rulemaking requirements the agency must follow. 150B 21.2, which provides notice and the opportunity for public comment. 150B 21.3A, which is periodic review of agency rules.
Well, that's all well and good, but it only applies to rules, regulations that are subject to the APA, and that's really the issue here, isn't it?
That's correct, Your Honor. And I would start with, my friends on the other side urge you to start with legislative history and the permitting statute itself. That's 143.215.10C.
Well, I have a more basic question.
Sure.
So I'd like you to respond to their argument that these can't be rules or regulations of general applicability within the meaning of the APA, because if you want to operate a waste management system, you have the choice. You can either apply for a general permit or you can apply for an individual permit. And council has said that if you apply for an individual permit, it's not the case that the principles or the requirements in the general permit are a starting point.
Your Honor, I would start with the text of the APA states that any agency regulation, and agency is a big word there. We've been dealing with this opt-in argument for the entirety of this litigation, and it's a hard one to square because I think it misses something. It's the agency's action that defines whether we have a rule here, not the applicant's decision whether they want to apply for an individual permit or a general permit. And we would contend and have argued in our briefing, and we can get into the record, that farmers aren't applying for individual permits just because they want to. There are specific situations where they do, but it's the agency action, and I think Justice Dietz was referring to this earlier. The general permits are pre-existing. They are put out available for everyone to determine. These are the rules. This is what a farmer has to comply with to operate their farm, and it has nothing to do. The general permit or the general applicability of the permits doesn't have anything to do with whether a farmer decides to apply for it or not. It's that there's a very inherent part of general applicability that is about.
Well, what does the general mean in general permit?
Yeah, and before the Court of Appeals, we provided several dictionary definitions because it's a term that's not defined in the statute, and we presented several that use the term most, meaning it applies to a broader cross-section of people. The Court of Appeals found that persuasive enough to include it in its opinion. And so we also noted that within the permitting statute itself, the General Assembly has expressly stated its intent that most of the general permits or most of the animal waste facilities operate under general permits. So there's a natural connection between the two terms there, that most is going to apply to a broader class of people. And so we would say that's a starting point. I'd also point you to 2 cases outside of this jurisdiction, Michigan Farm Bureau and the Tennessee Supreme Court's case in emergency medical care facilities, where both courts talk about the idea of a general permit being capable of being applied to or are relevant to an open-ended class or category of entities or situations. It's essentially most in our view. because you have a group of people, it's an open-ended class, and they are going to be able to come in and out of that permitting regime if they want to. But again, we go back to your question, just the option to pick one or the other doesn't defeat the idea of general applicability that those courts have described and the Court of Appeals described.
What seemed to me about the general permits to be distinct is, in addition to, I think you said, so that provision in 10C that says most will be general permits. So the mine run case is going to have to, of a farmer applying for one of these permits is going to be, I've got to comply with everything in this general permit. And then when you look at it, if each of the criteria was something that appeared in some regulation that did go through notice and comment and said, in order to receive the permit, you have to do this, it seems to me to be a harder argument for you. But as I understand it, you're saying this is posted. Permit applicants are shown this list of things we have to comply with in order to get a permit. It happens to be in the permit, not in some regulation. But that sounds like rules. I've got a list of rules I've got to follow. And then the problem is the agency has promulgated this without the procedural safeguards that our state constitution would require there, because it, as you pointed out, that's why we have the APA, that it provides those safeguards. And then this court has also said there's got to be rules review. There's got to be on the back end the General Assembly having the ability to say, this isn't what we were giving you when we gave you this lawmaking power. So, but your friend, as I understand it, is saying, but you can just get a special permit. So that's why the general permits aren't rules. What's wrong with that? Just why can't we say, well, if you don't like what you see in this list, just ask for a permit that doesn't have it in there?
Well, again, back to the comment I made to Justice Allen, I just think it's not on the applicant to determine whether a law is general or an agency action is generally applicable or not. You have to look at what the agency action does and its general purpose in being put out there. But again,
what about your friend's argument that instead of saying put this through rulemaking, you could just say this is unlawful, and that could be your claim?
Yeah. So, Your Honor, I'd go back to those protections in the APA that I was going through at the outset, because they're going to give the general public the opportunity to engage. And I know that the sue and settle issue is not before you, and so I don't want to go too much into the facts there. But part of the reason we're here is because the initial starting point of this case was a dispute where some community groups filed a civil rights complaint with the EPA alleging that these permit conditions were discriminatory on the basis of race. There was a negotiation process to resolve that dispute between the agency and those individuals absent the farm interests that were concerned about that discussion. And as a result, we ended up with a draft swine permit that was negotiated by those parties that contained permit conditions that had not been adopted as rules. And then that got presented as a starting point. And so there was notice and there was public comment and notice, but there were no other procedural protections other than that. There was no rules review process. There was no opportunity for legislative review. We'd also note that with respect to the groundwater monitoring requirements and the plat requirements, there was no substantial economic analysis or fiscal note provided. So farmers couldn't tell how much is this going to cost if I have to put this into place. And we don't think, Your Honor, you have to go to OAH to solve every single problem. The administrative process should set up protections so that you can work through that as part of that effort and get to a good result without having to resort to litigation.
So one problem I have with the department's position is it seems like I'm struggling to find limiting principles for all this. And it seems like under their view, and maybe they can respond in rebuttal, but would essentially allow them to adopt as a general permit condition any kind of measure that they could adopt as a rule with respect to waste management systems. And tell me if you think I'm wrong about that. But that then, it's difficult for me to believe that the General Assembly's intent in enacting the permitting process was to enable the department to essentially avoid having to engage in rulemaking.
I agree with you, Your Honor, that that's not what the General Assembly intended when it adopted the permitting statute. The permitting statute sets out, and this is 143.215.10CA, It says every farmer has to have, and I'm paraphrasing, every farmer has to have a permit to operate. There are two types of permits. One is a general permit. There are also individual permits. It is the intent, this is the General Assembly speaking, it is our intent that most of the animal waste systems be general permits. And when the Environmental Management Commission, and by delegation the division, conclude in its discretion that it's necessary to have an individual permit, we can issue one to protect water quality. That's the fundamental structure of that statute. But outside that, there is no limiting principle in there as to what they can do. But the limiting principle, Your Honor, is the APA. And that definition of rule, which we contend is broad, and these conditions look, act, and operate like rules, but they weren't adopted as that. And again, those protections would be there to work your way through. So I would say the APA is the limiting principle there. And if an agency is operating outside of that broad definition of rule, then they violated the APA. It's our contention that the General Assembly intends for a lot of agency action to go through the rulemaking process because, as I said, there is an important element in the APA of public comment and interaction with the agency. Otherwise, an agency can go off into its black box and make decisions, and we would contend that's sort of what happened here with the sue and settle issue, and then you end up in a position where you're having to go to OAH to defend everything, and that's going to cost time and effort and money when you can fix it in the front end with the APA.
And so is it your contention then that any conditions of an individual permit also have to go through the rulemaking process? And how could that possibly be consistent with the statute that is telling the commission to, act expeditiously, process a permit application as quickly as possible, and makes clear that you can't deny or attach a condition to a permit except when the commission finds that denial of conditions are necessary to effectuate the purposes of this part?
Your Honor, we would say it's consistent because if the agency has, or the EMC has gone through the rulemaking process on behalf of the division, and they have that grouping of rules that they can use to respond to those particular situations, then they're available to be used in the individual permit. Otherwise, what would end up happening is the agency could, under the statute, force a farmer into a particular situation where they're going to have to deal with the agency on an individual permit basis. And then that could be the end run around the APA. That would be our concern with that. So if the permit conditions themselves have gone through the rulemaking process, the actual general permit doesn't actually have to go through the rulemaking process. The individual permit doesn't have to go through it, but you've got that setup of those conditions that are available for you to use.
So the statute in Section E also has 8 different components that any animal waste management plan must have. And is it your contention that any permit, I guess whether general or for an individual, that any of these conditions also have to go through the rulemaking process?
Well, these are in statute, Your Honor, so they may not have to go through that. Your individual plan wouldn't have to go through the rulemaking process. And
so if the conditions in the general permit are specifically tied to one of these 8 elements, then those don't have to go through rulemaking.
No, I'm not sure I'm following your question.
Well, my question is, if the conditions of a general permit or an individual permit are specifically the same, if you will, as E1 through 8. So a checklist of potential odor sources and a choice of site-specific, cost-effective, remedial best management practices to minimize those sources. To get a permit, you have to show that you have that checklist. If that's one of the conditions, you're not saying that also has to go through rulemaking.
No, I would say that the animal waste plan, if you're following these components, you're following the statute. And that would be, that's a different source of law for something you could include in the general permits as a condition. They could be backed up by that statute.
And similarly, if there are conditions that have already gone through rulemaking, those are...
Absolutely, Your Honor.
So as I understand your argument, the key thing that's going on here is the language of 10C, where the legislature said, we want you to have a system of the individual permits, but also the general permits. And by the way, they better all be general permits. Most, whatever most means, most are going to be general permits. And then you have this situation where you can see the general permit ahead of time. You know exactly what's in it. And it's combining those two things that's creating the problem Justice Allen described, where if you start sticking things in that permit that could be rules, but instead you put it in the general permit and let everyone know ahead of time you're going to have to comply with this. It's an end run around the APA. It's a way to take a rule and not subject it to rules review and the procedural safeguards, but have everyone know it's universal, they have to follow it anyway.
Mhm.
That's the argument.
That's correct. And
Can you tell us why adopting your approach wouldn't be gutting the permitting process?
I don't think you have to gut the permitting process to rule in our favor. The issue presented is very narrow, and are these three conditions in these general permits rules. And so you could write an opinion that is very tight on that particular issue. You don't have to, as I said earlier, reach the question of whether the permits themselves are rules to rule in our favor. And again, as I mentioned to Justice Earls, it's our contention that once you have a process by which those conditions are being put through the rulemaking process, and the agency is following those and statutes and putting them into the general permits, you don't necessarily have to have that protection on the permits themselves. So I don't think it's going to blow up the permitting system or anything to that point, to that extent. I do think it puts an extra check in the process for the agency when they are working with these general permits. And I would note that these general permits are unique compared to other general permits that the General Assembly has created. Those permits, and this is at 143.215.1D4, those general permits deal with minor activities. So if you're building a home, there are certain there's a construction stormwater permit that deals with the general basic processes of building a home. But a hog farm is different. I would contend, and some of my farmer members may not like this, but that's not a minor activity. And so these permits were created differently by the General Assembly. That's why they have a whole separate section, in our view, in the general statutes versus something that could have been addressed in that 143.215.1 section.
Yeah, so to put my question differently, if all the conditions in the permit have to be located or come from a regulation or a statute, what purpose is served by the permit?
So in the context of these individual permits, it is efficiency. And I would note that in 143.215.10A, and that's the statute that it sets out really the purpose of this. I'm going to try to find it so I can quote it to you. Excuse me just for a second, Your Honor. And so this is the first section of these animal waste management systems. This is part 1A of chapter 143. And down the line is that the General Assembly finds that animal operations provide a significant economic impact and other benefits to the state. Down the line, several chapters, quote, to this end, the General Assembly intends to establish a permitting program for animal waste management systems that will protect water quality and promote innovative systems and practices while minimizing the regulatory burden. There are over 2,000 farms that operate under this general permit. And for those individual farmers and for the agency, this general permit process is pretty quick and routine. You apply for a certificate of coverage, you get a letter sent back saying you're covered under this permit, and you follow those conditions. If you're not going to go through that process, if you're going to go through the theoretical option that the agency is proposing to you, then you're going to have to, and it's in the record at, I think it's Doc X 303, where we're talking about the steps of the development of the permits. And I'm not going to get this exactly right because I'm doing it off the top of my head, but they receive the application, they evaluate it, they'll investigate it, they may come out and do a site visit, and then they'll apply any type of conditions that they think are necessary under that individual permit process. What they cannot guarantee is that you're not going to get stuck with the conditions that are in the general permit. They equivocate with the, maybe we'll put all the general permit conditions in. Maybe we'll put some that are more stringent in. Maybe we'll put some that are less stringent. But you just don't know. You don't know what you're going to get through that process. So the only reason you would try to apply for an individual permit is to avoid an onerous general permit condition. But if you don't have that guarantee, why would you ever make that choice?
So what happened, if we affirm the Court of Appeals, what happens to those 2,000 permits, general permits that are out there?
The ones that are currently in force, these three conditions are just not enforceable. The rest of the permit conditions will move forward, even the ones that aren't backed up by a rule because they weren't challenged. Now we have, the permits are in process for another cycle. They would have started in 2024, but the General Assembly extended those for a couple years based on this decision. Or this case being out there and the agency needing time to figure out what to do. So there's an opportunity for them to address this, for us and the regulated community, environmental groups that are interested in this, to address that through the next permit iteration.
By going through the rulemaking process?
Yes, Your Honor. And Farm Bureau engages in the rulemaking process all the time. It does take time, but again, it's a process by which everybody gets heard. The rules are out in front where everybody can see them, and it takes time, but that's the balance that the APA reached. That is the understanding we have under the Administrative Procedure Act. And there are temporary rules in situations in which agencies can move forward with more expeditious effect. They can, through that temporary rulemaking process, they can limit the time for public comment. There are also emergency rules that are available in certain situations. So there are ways to act. May not be as fast as they want, but they can act. Your Honors, I would, we've heard a couple times at the beginning this idea of legislative acquiescence. I want to make clear that that's a rarely used canon of construction, and it applies really when a court has decided a particular or interpreted a particular statute, and the legislature has taken a little while to decide whether it wants to act or not. And so any kind of argument they're making about legislative acquiescence just doesn't apply here, because the court hasn't. This is the first time our courts have considered this kind of question about what's the balance between the APA and this permitting statute. So legislative acquiescence just isn't appropriate here, because you're trying to divine some kind of legislative intent from its silence. And as a recovering lobbyist, sometimes you don't know what happens down there and why they make the decisions they do. That's no besmirching any legislator, but it's the process. It's a messy one down there at the General Assembly. So you don't really, it's hard to ascertain what the legislature is doing. I would also note that the argument that my friends on the other side made in their brief, it was a long one about legislative history and adopt and issue and all of those things. Those seem like implied exemption arguments. And of course, this court has said many, many times there aren't implied exemptions to the definition of rule or to the APA unless there is a clearly stated legislative expression of that. And over 10 pages of briefing, to me, doesn't indicate a clear statement of a legislative exemption there. So as I said at the outset, the APA sets out the definition of rule. We contend that those general permits fall into that rule, and the conditions fall into that rule, and there's no exception applies. And so if there are no further questions, Your Honors, if you rule against this, which I hope you do not do, I would ask that you remand this matter back to the Court of Appeals for discussion on the sue and settle issue. But if you would accept Farm Bureau's position here, we'd ask that you affirm the Court of Appeals. Justice Dees.
One clarification. So is your argument that the general permit itself is a rule, or that the monitoring wells, the runoff, and the analysis provisions are the rules that need APA?
Certainly the three conditions are rules. You don't have to decide that the general permits are conditions, or that the general permits are rules to rule in our favor. But I would argue they do operate like rules in a lot of contexts. With that, we'd ask you would affirm the Court of Appeals. Thank you, Your Honor.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. And I'll be very brief. So to begin with, my friend makes a lot of allusions that a good portion of our brief is legislative history. This is not legislative history, as that term has been understood and has been criticized by some members of this court. This is not committee reports. It's not floor speeches. All the past legislation is all enacted statutory text. This is direct evidence of what the General Assembly as a body intended, not what one legislator or one committee staffer believed. So it's simply not a sufficient response to wave it all away as legislative history. And with regards to legislative acquiescence, in their brief and then again today, our friends pretend that legislative acquiescence only applies when there has been a judicial decision, and that's not consistent with this court's case law. We cite the case of Wells versus Consolidated Judicial Retirement System. It's really on fours with this, all fours with this case. In that case, there had been a prevailing administrative interpretation of the statute for 2 decades, and this court relied on that legislative acquiescence and said that when there has been a prevailing administrative interpretation and the General Assembly has declined to change it, we assume that the General Assembly is satisfied with that interpretation. So it's just not accurate to say that legislative acquiescence doesn't apply unless there's a court decision. And finally, to your point, Justice Allen, with regard to a limiting principle, it's not the case that the department can craft whatever condition it thinks it wants to. For each of these conditions, by statute, we have to point to a specific statute or regulation that provides the authority for that condition. And as we went through earlier this morning, if the permittee doesn't believe that's accurate, they can challenge it. Thank you, Your Honor.
Thank you, counsel.
All rise. Yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state